Hi, this is Curt and welcome to another edition of Fire Law Roundup.
First, as a really easy one in Missouri, and I've got a point of this that I want to make out of this, but a Missouri fire district settled a reverse discrimination suit. And look, this was filed 12 years ago. They ended up paying out $250,000. There was actually a verdict that got reversed just as I guess like a mistrial or something. But in any event, they ultimately settled. But it's not exciting, right? For purposes to say, oh my God, but it's 12 years. So that's what I want to point out to people before you go down the road, either way of defending or prosecuting a lawsuit, you better make sure you're ready to be in it for the long haul. And, I was meeting with some friends yesterday and they're talking about lawsuits and they have one going on for years. And, I just finished a ton of them that go on for years, and the toll it takes on people is significant. And you'll be out of your position as fire chief or whatever long before some of these things settle. So really my lesson from the Missouri settlement is this goes on forever. And are you sure you want to get into that? Whether it's prosecuting, suing out, or whether it's defending, is it worth the next decade of your life? And then the question, what happens is, what do you do in the interim? Are you fixing the allegations, whether right or wrong, or are you too afraid to say, oh my God, we don't want to look like we did something wrong, so we're just going to leave it status quo? So I throw this out to everybody to, before you say, oh, we're going to sue, or no, let's defend it. Maybe there's another way. Sorry to put all the lawyers out of business, but maybe there's another way. Okay,
But
let's
get into the details of it though, because it's kind of an interesting case. This involves the Northeast Ambulance and Fire Protection District. And for those of you in the Missouri area, I don't think we have to point out that they've been involved. They went through a number of challenges roughly 10 years ago, and a bunch of lawsuits. I've got 15 or so involving there, or not all lawsuits. Some of them are disciplinary actions, but they had a First Amendment case that went up to the Eighth Circuit. Pretty interesting social media email case in First Amendment and releasing information to the media. So it looks like this case, the one we're talking about by Harold Connor, sort of predates that a little bit, but there's quite a bit of turmoil. And that's not uncommon that you see a fire department go along and then all of a sudden you get blitzed by a bunch of disciplinary actions, civil suits, and then I guess the state had to come in and intervene over some of the issues that were going on in the department. So, this isn't your typical fire department. All of a sudden, boop, we got one lawsuit, and then this was sort of part of a pretty big problem. And Mr. Connor prevailed at trial, and then there was a JNOV, and not even a JNOV, just a new trial ordered, and the resolution was a $250,000 settlement. So. We're going to talk about some other discrimination cases in a bit, but I do want to point out when it comes to race discrimination, that's the second most likely type of discrimination that we see. Sexual harassment, gender discrimination is number one. Race discrimination is number two, and there's a ratio in here, and it's changed a little bit each time I do it, but it's roughly 2 to 1, two minorities.
Over gender discrimination?
No. Two minorities to one reverse discrimination. This is a reverse discrimination suit. So now it's been as high as 2.5 or so, but generally it's in the range of 2, maybe a little bit over 2 minorities to every one reverse discrimination case. So, it's bottom line is it's not a one-way street. And I think a lot of people tend to think of it as a one-way street, but it's not. I mean, discrimination on the basis of race is a violation of Title VII and maybe violations of other things as well. So interesting to, keep in mind.
And look, I've always commended you. And I when I teach at the Fire Academy or wherever, I say, if you really want to know where do we start on reducing our liability, your database is it. I mean, the percentages tell you where you need to spend your efforts. And it's not on negligent driving and negligent. I mean, we've seen some of that, right? But it's not on the operational activities that is really causing you the grief. It's your own internal theoretical mismanagement, harassment, discrimination. And the third one we get to today is going to be extremely interesting. But as we spend the rest of the time talking about discrimination, the way, well, we'll get into it, but the way you react matters. So, I think people need to be looking at where can we cut our risk, right? This is a kind of risk management, and you want to know where to cut the risk. Simple, right?
Well, I know as a young firefighter, a young company officer, even shortly after I got, started practicing law, got through law school, what would keep me up at night would be Mrs. Smith type lawsuits where we didn't get to Mrs. Smith's house fast enough, or we didn't do a good job, or we got in an accident. And not that those aren't important. It's just that that's not the most likely way we're going to be sued today. And that includes company
immunity
officers.
Protections, right? I mean, the things we do in the field, there's immunity protections. There's no immunity for harassment and discrimination.
No.
So,
or FMLA or FLSA. So
yeah. And by the way, if you're watching this and even signed up for the Family Medical Leave Act seminar on Wednesday, now's the time. Third offering, great reviews. I love doing it. And your employees know this stuff. So it's
important.
It
yeah.
is.